Thank you. It's been a long 2 days for everybody, so I will be brief. I think you're ready to move into the time when it's time for you to do your jobs. And so first of all, I want to thank you for your time and attention and your patience with both of us, and I'm sure I speak for the other attorneys and Mr. Gardner as well. I want to address just a couple of things first. Mr. McKinnon said during one of his objections that the county only wanted to bring out the bad things and that we were trying to hide the good things, but that's not really true. You recall back at the beginning yesterday during our opening, we said we're not going to dispute that he was a good employee, that he was a hard worker, and that he did a good job. We said that from the very beginning. Mr. Reckenwald said when he testified that that was something that he took into account when making his decision. And I think he even said that's made the decision even harder because of the background of this officer in the long-term employment. So the county's not trying to hide the job that he did when he worked for us. But in looking at a person or an employee's actions, there are things that occur or that are done that can't be overcome by a good record or a good job or long-term employee. There are things that happen that people do that can result in termination, and that's what happened in this case. The attorneys for Mr. Gardner have brought up a lot of things about the internal investigation in this case. You know my position on that. We believe you've been given all the information about the two parts of the investigation, that Mr. Gardner certainly got due process. He was allowed to give one statement. He was asked to give another statement. He was then asked by Mr. Smith in a letter form to please provide anything you want me to consider or you want the appointing authority to consider before a decision is made. And at the end of the day, even if there was a shoddy investigation, which I certainly am not conceding, the facts are the facts. The facts are what they are. You heard them from the witnesses that testified. They didn't have anything to do with how the investigation was done. They spoke, and I think it was very difficult for some of them who are close friends of Mr. Gardner to come in here and say the things that they had to say or needed to say about the relationship between he and Ms. Gittner. There's been testimony about, or discussion, I'm sorry, about Ms. Stoffelmeyer's investigation, and actually her report of investigation has been admitted into evidence for your consideration. And I want to point out one thing. They've talked a lot and brought out a lot of things about what she did not sustain in her investigation. And what I want you to hear and to focus on, if you look at this report, is what she did sustain in her investigation, which was the first part of this investigation. And what she found were sustained. The finding of officer misconduct associated with allegations 1 and 2 is sustained. 1 and 2, the things that were sustained were the conduct of employees under 86, the Code of Conduct, which is also the one that was relied upon by Mr. Reckenwald, number 86-45 on the letter of termination right at the bottom of the second page, 86-45, conduct of employees. Captain Stoffelmeyer sustained that finding in her investigation. She also sustained the finding under 86-453, number 13, any conduct on or off duty that reflects unfavorably on the county as an employer. She further sustained something that Mr. Reckenwald did not even include, so I won't even mention that one, dealing with gifts and gratuities. She sustained that one, but there's been no evidence about that because he didn't rely on that. And finally, she sustained the neglect of duty, which is on the third page of the letter of termination, the 11.01.05. Captain Stoffelmeyer, at the conclusion of her investigation, sustained those very same things that were found by Mr. Reckenwald's independent review of the entire investigation. And I think that's important that you know that, because there's been a lot of discussion about what she didn't sustain, and you need to know that what she didn't sustain was not relied upon by Mr. Reckenwald in making the final decision. I want to talk briefly about the letter of dismissal and what Mr. Reckenwald told you, other than the things we just discussed. Mr. Gardner was charged, and it was found by Mr. Reckenwald that he violated a reasonable or official order given by a supervisor or other acts of insubordination. And you've heard all the testimony you need to hear probably want to hear about the phone records. And I think the county established through Mr. Gardner's own testimony that he did use his personal cell phone for county business. We believe we presented to you a court case that says that makes those records public record. The court case says the actual text messages would be a public record. That wasn't what was sought in this case. The only thing Mr. Pozo ordered him to produce were records related to on-duty time phone calls between Mr. Gardner and Ms. Gittner and Ms. Winters. And the only reason those were ordered to be produced, and the two ladies produced their cell phone records, by the way. They complied with this order. So if it's an unlawful order, it's been complied with by the two ladies. The purpose of the request was because a witness in the investigation said, who worked for Mr. Gardner, Kyle McDaniel, who was with him for the last year, worked for him, said his phone was going off 100 times a day. They were texting or talking on the phone all the time. So in doing his investigation, Mr. Smith felt it might be relevant information to find out whether or not they spent a lot of their county time, because that certainly would be a violation as well. But at the end of the day, because he didn't produce the records, there was no way to determine that information, whether or not they spent county time on personal business or an exorbitant amount of county time on personal business. So Mr. Rechtenwald didn't rely on that at all. That doesn't change the fact that he refused to obey an order of a superior. He didn't follow the procedure. If you believe it's an unjust order, you're supposed to comply and then send a letter up the chain of command. He didn't do what the policy required, and he disobeyed a direct order. That's insubordination. That's a penalty subject of determination. That's a fairly simple violation to consider in terms of the evidence. The other one, the second one, I'm going to go to the third one first, the unsatisfactory performance of duties. Again, the facts that support that finding by Mr. Rechtenwald have to do with this gun incident with Officer Gittner. And I believe the county established that while Mr. Gardner wanted to say it was a big joke, basically, that she laughed at him when he asked, the truth of the matter, by his own admission, was he took her service weapon and he took her personal gun, and she was upset, and she testified, and you decide how you judge her credibility. It was obviously very difficult for her to come in this room with all of Mr. Gardner's supporters here. She testified that even though she didn't intend to harm herself, she believed that he thought she did, and that's why he took her guns, including the personal gun. And the next morning, at her request, he just returns them. And Mr. Rechtenwald, I thought, did a very good job of explaining why that was wrong. There is a merit rule that requires people, or that allows for an appointing authority who believes an employee may be under duress or unable to perform the functions of their duties to get a fitness for duty. Mr. Gardner was aware, maybe not, I don't know if he was aware of that merit rule, but he knew that in a law enforcement sense, that if somebody is depressed or upset to the point where they can't do their job as a law enforcement officer, that they need to be determined whether they're fit for duty before they're given their gun back. And that's all he had to do to not be in trouble for this, to not have this be a sustained finding, was tell his friend, Kevin Sweat, who they have all this camaraderie on the beach, they're close, his office is right down the hall, they talk to one another every day. I submit to you that he had enough of a relationship with Director Sweat that he could have just called him and said, I got a problem. But because of the level that he has attained in the organization, and because I believe he thought he could get away with it and no one would ever know, and in fact, no one would have known, but for, y'all heard a little bit about this anonymous letter that started this investigation. That's what started this, an anonymous letter. So despite the fact that we had a lot of witnesses talk about how great Rich Gardner was, there was somebody who felt the need to report, or felt so uncomfortable with his behavior with these two employees, subordinate employees, they reported that, and it was investigated, and that's why we're here today. So the unsatisfactory performance of duty violation that was sustained by Mr. Rechtenwald has to do with his handling of the gun incident and his failure to report that to up the chain of command, or at least to his friend Kevin Sweat. Knowingly giving false statements to supervisors. There's been a lot of discussion about the question that was asked by Kevin Sweat and the response that was given. And I think I'm going to leave you with the facts, the description given to you by Mr. Rechtenwald about the lie of omission. And in addition to it being a lie of omission, he was such a good investigator, he knew that he could answer, he knew how to answer that question, not to get in trouble. But I submit to you that he was having an inappropriate relationship at the time he was asked that question, and that he lied, whether Kevin Sweat thought it was a lie or not.